Lecture 2. Homicide. Actus Reus and Causation. Murder. Under English law, homicide is used as a generic term which covers causing the death of another human being. Murder is the most serious kind of homicide, and the distinguishing factor is that the defendant must act with a specific intent. Following the Murder, Abolition of Death Penalty Act, 1965, it is punishable by a mandatory life sentence. The judge does not have any discretion in sentencing other than to consider a minimum term before a prisoner can be released on license. Definition of murder. There is no statutory definition of murder. The definition laid down by Sir Edward Coke is still applicable today. Murder is committed when a man of sound memory and of the age of discretion unlawfully kills within any county of the realm any reasonable creature in being under the king's peace, with malice aforethought either expressed by the party or implied by law, so as the party wounded or hurt die of the wound or hurt within a year and a day after the same. Hence, the major elements of murder are: the killing must be unlawful, the victim of the homicide must be a person, being, and must be under the jurisdiction of the United Kingdom. Hence, it can be committed anywhere in the UK or on any British ship or aircraft. Actus Reus. The actus reus of murder is satisfied when certain elements are fulfilled. The killing must be unlawful. It is lawful to kill another person, for example, when enemy soldiers are killed during battle, in cases of death penalty, and in self-defense. General principle. The victim of the homicide must be a person. Attorney General's reference, 1996. Facts. A man stabbed his pregnant girlfriend in the abdomen. She gave birth prematurely, and the baby died some 4 months later as a result of its immaturity. The defendant was acquitted of murder at the judge's direction, and the Attorney General referred various points of law to the Court of Appeal. Ratio. Lord Chief Justice Taylor said the elements of the actus reus of murder are that the defendant did an act that was intentional rather than accidental, that was unlawful, that was a substantial cause of the death of a person in being, and, as the law then stood, that the death occurred within a year and a day of the act. The mens rea is that, at the time of the act, the defendant intended either to kill or to cause really serious injury to the victim or, subject to the extent of transferred malice, to some other person. The House of Lords subsequently reversed Lord Taylor's judgment as to the applicability of transferred malice in this case, and disagreed with his suggestion that the fetus could be regarded as part of the mother, but this definition of murder appears to be sound. Application. The House of Lords held that a child was not a live person, and therefore this could not be murder. Causation. Causing death. The killing must cause the death of a person. What needs to be proved is that the acts or omissions of the defendant caused the death of the victim. Technically, causing death can be misconstrued because eventually everyone will die. The courts have acknowledged the fact and consider it equally liable to cause death. There are two important things to establish causation, both of which have to be proved by the prosecution. Firstly, the jury must be satisfied that the acts of omissions in question resulted in the relevant consequence. Secondly, it must be proved that the acts or omissions of the accused were a legal cause of the consequence. General principle. There must be a causal link between the act or omission and the death of the victim. Attorney General's reference, 1997. Facts. A man was charged with stabbing his pregnant girlfriend in the abdomen while she was pregnant. This led to her giving birth prematurely, and the baby died some 4 months later as a result of its immaturity. Ratio. The House of Lords said that the man could not be guilty of murder because he did not have the necessary mens rea towards the death of B, but had no doubt the actus reus of murder. The man's act changed the maternal environment of the fetus, said Lord Mustill, so that when the baby was born, she died, albeit of quote-unquote natural causes, and not of a minor injury sustained during the stabbing, when she would otherwise have lived. Lord Hope agreed and said that the actus reus of murder and manslaughter required evidence of an unbroken chain of causation between the defendant's act and the victim's death, the time interval now being unimportant. The presumed facts of the reference certainly created a prima facie case to go to the jury. Application. If the prosecution cannot prove a causal link between the defendant's act and the victim's death, there can be no conviction for murder. In deciding the issue of causation, the jury must apply the following legal principles. Factual causation, the but-for test. This is a question of fact. It must be proved that, but for the act or omission of the defendant, the relevant consequence would not have happened the way that it did, which means that in the absence of the defendant's act or omission, would the defendant have died. General principle. A factual link must be established between the act or omission of the accused and the victim's death. The Crown and White, 1910. Facts. Meaning to kill his mother, the accused put a few drops of cyanide into her lemonade. Soon afterwards, before drinking the lemonade, his mother died of a heart attack. Ratio. According to the but-for test, it must be established that the consequence would not have occurred, as and when it did, but for the defendant's action. Application. Since the medical evidence showed that the death of the mother was not due to poisoning, and no trace of cyanide was found in the body, the court acquitted the defendant on the murder charge. Legal causation. This is a question of law. Quite generally, a question becomes one of law where there is more than one operative cause. If I invite you around for dinner and throw a TV out the window as you ring the doorbell and you are thrown into the road, hit by a cyclist who throws you into the way of an oncoming car, and you die, who is the cause of death? The law will prevent a person from being responsible for everything that arises from his acts or omissions. The law will acknowledge the liability of the defendant before imposing any penalty. General principle. The consequence must be caused by the defendant's culpable act. The Crown and Dalloway, 1847. Facts. The defendant was driving a horse cart without holding the reins. A child ran in front of the cart and was struck by the wheels and killed. It appeared in evidence that even if the defendant would have been holding the reins, the child would still have been killed, as he would not have been able to stop the cart in time. However, if he would not have been driving the cart, then the child would not have been killed, so in that way he did cause death. Ratio. The issue for the court was to establish whether the consequence could be said to be the result of the defendant not holding the reins. Application. Evidence showed that even if the defendant had been holding the reins, he could not have stopped the cart in time. Therefore, the defendant was not liable. The child's death was not the defendant's fault. General principle. The defendant's act need not be the only cause of death. The Crown and Benge, 1865. Facts. Benge was a foreman of some railway track layers. He was under the impression that the next train was not due for a few hours, and so he ordered the track to be taken up. He asked a man to go down the track with a red flag to stop any trains. However, this man did not go an appropriate distance, and the driver of the train was not keeping a good lookout. The train crashed, and many people died as a consequence. Ratio. The issue for the court was that the deaths were a combination of elements: the defendant's misreading the train timetable, the signalman's failure to stand in the appropriate position, the train driver's failure to keep a proper lookout. Before a situation of multiple causes, the court focused on which one of them was the major cause of the crash. Application. The jury convicted the defendant on the ground that his conduct mainly caused the deaths. Murder and causation. General principle. To convict D of murder, the prosecution must show that the drink was given to the subject with the plan to kill, that the drink was a more than minimal cause of death, and that V's act of drinking was not a free, willing, and informed choice that would have broken the chain of causation. The Crown and Field, 2021. Facts. The defendant, D, was a young man who attempted to financially exploit an elderly man, V, by beguiling him. While posing as V's close friend, he influenced him to alter his will in favor of D by supplying him with alcohol and illegal substances over an extended period of time. Once this was accomplished, he carried out his plan to murder V by offering him sleeping pills and an entire bottle of liquor, which he knew V would be compelled to drink. V did so and perished of severe alcohol toxicity as a result. Ratio. The judge instructed the jury that in order to convict D of murder, they must prove that the drink was given to the victim with the intent to kill, that the drink was a more than minimal cause of death, and that V's act of drinking was not a free, voluntary, and informed decision that would have broken the chain of causation. The court's primary concern was with causation. If V's consumption of alcohol and narcotics was voluntary, free, and informed, then causation was not established under the Kennedy, number 2, principle, and the murder charge would be dismissed. Although the victim voluntarily consumed the alcohol and/or medication, the judge instructed the jury that D could still be culpable of homicide. In essence, he lacked an informed understanding of the truly dangerous nature of the situation. In agreement with this analysis, the Court of Appeals upheld the conviction. Application. In contrast to the Kennedy case, the victim in this instance was not fully aware of the consequences of injecting the substance. Rather, this victim was deceived into believing he was in secure hands with a person who loved him, when in reality he was being lured into a dangerous situation with a murderer. Intervening acts, or acts which break the link of causation. This is where the act of a third party breaks the causal effect of the original defendant. The courts have to decide whether the link of causation has been broken, and can the defendant be held liable in such situations. General principle. Courts are reluctant to consider medical negligence as breaking the chain of causation. Crown v. Smith, 1959. Facts. Smith and Creed were involved in a fight in barracks, in which Smith stabbed Creed with his bayonet. Creed's friend took him to the first aid post, but on the way he tripped over and dropped Creed twice. When they got there, the medical officer was busy and took some time to get to Creed. Creed died about 2 hours after the stabbing, but had he been given the proper treatment, he probably would have recovered. Smith was charged with murder. Ratio. The treatment he was given was thoroughly bad, and might well have affected his chances of recovery, said Lord Chief Justice Parker, but medical treatment, correct or not, did not break the chain of causation. If at the time of death the original wound is still an operating cause, and a substantial cause, then death can be said to be a result of the wound, albeit that some other cause is also operating. Only when the second cause of death is so overwhelming as to make the original wound merely part of the history, can it be said that death does not flow from the wound. Application. Generally, medical malpractice does not break the chain of causation. Therefore, the defendant was not convicted. General principle. Bad medical treatment does not break the link of causation. The Crown and Cheshire, 1991. Facts. The defendant shot the victim in an argument, and the victim was taken to hospital where a tracheotomy was performed. 6 weeks later, the victim suffered breathing problems as a result of the tracheotomy scar and died. The hospital had been negligent, perhaps even reckless, in not recognizing the likely cause of the victim's problems and responding to them. Ratio. The defendant's actions need not be the sole or even the main cause of death, as long as they contributed significantly to that result. Medical negligence does not exclude the defendant's liability unless it was so independent of his acts and so potent as to make his own contribution insignificant. Application. Only in the most extraordinary and unusual case would treatment, whether right or wrong, given in good faith by a generally competent doctor, be regarded as independent of the original injury. The Court of Appeal held that this did not break the chain of causation from the shooting. Intervention of third parties. General principle. There will be a break in the chain of causation only if the acts of the third party are free and informed. The Crown and Paget, 1983. Facts. Paget was convicted of manslaughter following the death of his pregnant girlfriend that had been hit and killed by police bullets while Paget was using her as a human shield. Ratio. The judge, while directing the jurors on causation, opined that they had to be sure that the accused had first fired at the police officers, and that act caused the officers to fire back, which resulted in the girl being killed. The jury had to be satisfied that the police officers fired in self-defense or while performing their duties as a police officer. If the jury was not sure about these two, then the link of causation would be broken. The jury convicted Paget. The decision was appealed. The Court of Appeal said Paget's act was not only a factual cause of Gale's death, but a legal cause too. It was an unlawful and dangerous act, and the police return of fire was a foreseeable consequence. Application. There will only be a break in the chain of causation if the actions of the third party were free, deliberate, and informed. New acts intervening. Novus actus interveniens. The Crown and Grant, Tony Lee, 2021. Facts. The defendant, A, was the occupant in the front seat of a vehicle piloted by B. While seeking for two specific victims to attack with weapons, B, upon locating the men and crossing the road, intentionally veered into them and killed them. A argued at trial that B's decision to run down the victims, instead of waiting to attack one or both of them on foot in a face-to-face confrontation, was such a departure from the agreed-upon plan that it constituted an overwhelming supervening act, novus actus interveniens, rendering A guilty of manslaughter as opposed to murder. The judge disagreed and refused to submit the issue to the jury's decision. Ratio. The Court of Appeal dismissed A's appeal, holding, among other things, that the central issue was whether Grant's conduct was so distanced in time, place, or circumstances from the conduct of the perpetrator that it would not be realistic to regard his or her offence as encouraged or assisted by it. The Crown v. Jogi, 2016. Not the case in this instance. The thin skull rule. The thin skull rule refers to the principle that the defendant must take the victim as he finds him. This means if my victim is prone to internal bleeding and I hurt them unknowingly, I am still responsible for their injuries. General principle. A person who inflicts harm on another cannot simply escape liability if the victim, due to some pre-existing infirmity, suffers greater harm than would be expected as a result of his act. In other words, the defendant must be taken as he or she has been found. The Crown and Hayward, 1908. Facts. The defendant threatened his wife with violence and chased her out of the house, where she died from a rare medical condition aggravated by violent exercise and fright. Both defendant and wife were unaware of the medical condition. Ratio. The issues for the court were: firstly, whether the defendant was liable even if he did not physically touch her. Secondly, should the peculiar medical condition of the victim have been taken into account. An ordinary person of reasonable fortitude would not have died in the same circumstances. Application. Mr. Justice Ridley told the jury that death from fright alone, caused by an illegal act such as a threat of violence, was enough to sustain a charge of manslaughter. The defendant had to take the victim's condition as he found it. The defendant could not escape liability on the grounds that the death was caused by a medical condition. Acts of the victim. This issue generally arises in fright and flight cases. The issue falls on the question whether such escape was foreseeable by a reasonable man. If not, then the defendant can be acquitted. General principle. There must be some proportionality between the gravity of the threat and the action of the deceased in seeking to escape from it. The Crown and Mackey, 1973. Facts. The defendant threatened his 3-year-old stepson with a severe thrashing for some minor misbehavior. The boy tried to run away but fell downstairs, dislocated his neck, and died. The defendant was charged with manslaughter. The man was convicted, and his conviction was upheld by the Court of Appeal. Ratio. The judge had put 4 questions to the jury. Was the boy in fear of the defendant? Did that fear cause him to try to escape? Was that fear well-founded? Was it caused by the defendant's unlawful conduct, allowing for the fact that defendant was in loco parentis and could lawfully administer reasonable punishment? These were the right questions, and the jury had evidently answered each of them affirmatively. Application. The defense that the boy had effectively killed himself by running and falling down the stairs was not accepted by the court. General principle. If the victim has bled to death from the original wound, his act or omission done to commit suicide will not break the chain of causation. The Crown and Deer, 1996. Facts. A man attacked another man who had allegedly molested the defendant's 12-year-old daughter, cutting him repeatedly and deeply with a Stanley knife. The victim died 2 days later, and the defendant was charged with murder. On appeal, the defendant argued that the victim had in fact committed suicide by reopening his healing wounds, or alternatively by failing to stem the bleeding from them after they had reopened themselves. Ratio. The Court of Appeal said if the victim mistreats or neglects to treat his injuries, this would not break the chain of causation. Application. The jury was directed in considering the defendant liable, since the victim's wounds were still the operating and substantial cause of the death. The defense that the chain of causation got broken due to suicide or failure to take steps to staunch the blood flow were not available. Refusal of medical treatment. In these cases, the courts have to decide the position when the victim refuses medical treatment. General principle. Even if the victim refuses medical treatment, the defendant will be liable for causing the death of the victim. The Crown and Holland, 1841. Facts. The defendant assaulted the victim and injured one of his fingers. A surgeon advised the victim to have the finger amputated to prevent infection. The victim refused and subsequently died of tetanus. Ratio. The defendant was held to have caused the death of the victim. The fact that the wound did not instantly cause death and became a cause of death after the victim refused treatment did not matter. The only issue that needed to be established was whether the wound was the cause of death. Application. Refusal of medical treatment by the victim could not be used as a defense for murder. The defendant was held liable. General principle. The defendant cannot escape liability on the grounds that the victim had refused treatment on religious grounds. The Crown and Blau, 1975. Facts. The defendant stabbed an 18-year-old woman and punctured her lung. At the hospital, the woman was told that she would have needed a blood transfusion to save her life, but she refused this as contrary to her religious beliefs. She died the next day. The defendant was charged with murder, which was subsequently reduced to manslaughter by reason of diminished responsibility. Ratio. It has long been the policy of the law, said Mr. Lord Justice Lawton, that those who use violence on other people must take their victims as they find them. This principle clearly applies to the mental as well as the physical characteristics of the victim, and the courts will rarely make a judgment as to whether the victim's response was reasonable. Application. The defendant could not escape liability because the victim had refused treatment on religious grounds.